Thanks everyone for joining us today on this Wednesday morning. My name is Jiyae Hwang. I am a senior attorney at Scott Legal PC, and today we're going to spend some time talking about the EB2 National Interest Waiver, the NIW, which is a green card pathway that allows self-petitioning for certain individuals with advanced degrees or exceptional ability. As we will discuss in the presentation, this can be a great option for entrepreneurs as well. Just a few things before we get started. So Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are actually doing at least 2 webinars a week on different immigration law related topics. So please feel free to join us for any upcoming webinars in the future as well. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. So first, we will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a guide, a visa guide, a comprehensive guide that you can use as a resource regarding the national interest waiver. We will also send you a link that you can follow to sign up for any of the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button, as we do regularly upload a variety of immigration law related videos that can be helpful to you. Finally, we will send you a link that you can follow to set up a consultation with me or one of our experienced attorneys, should you wish to discuss your case in further detail. So today I will be presenting about the national interest waiver. I am a senior associate at the firm with a wealth of experience handling EB2 NIW cases in a variety of fields. And I'll be sharing my insights about how you can qualify for a green card under the EB2 NIW category. Finally, for any questions you may have, if you have any questions at all, please feel free to add them to the chat box or use the Q&A function to write your question, and I will try and get to all questions at the end. So without further delay, let us get into the presentation. All right, so let's start with an overview of the national interest waiver. So what is an NIW? What is it when people talk about the NIW? So the NIW is a green card option that can be available when the government concludes that you are coming to the United States to do something that is in the national interest. And what you need to understand is the NIW is a subset of what is called the EB2, the second preference employment-based green card category, which is usually processed through what is called, when a U.S. company has a job offer for you, and the U.S. company is typically used to, required to go through what is called the labor certification process, testing the labor market to see if there is any other U.S. Potential employee who can take your job before the U.S. company is allowed to sponsor a foreign national for that job. So that is the usual process that an employer must go through to, so that a person can qualify for a green card under the EB2 category. So that's the umbrella category that we're talking about now. The NIW is a subset of that. And if you qualify for this subset, through the NIW pathway, you're exempt from this process. You're exempt from, needing a job offer. You're exempt from, needing to have a U.S. company go through this time-consuming process of testing the labor market to see if there is another U.S. person who can take your job before, you can qualify for a green card. It's kind of like a fast track where you're exempt from, going through that. So because of this, it is more difficult to qualify for a green card under the EB2 NIW subset, because the ordinary pathway is through, the labor certification process. Really, anyone can qualify for a green card if they have a job offer and if the U.S. company tests the labor market and can prove that there is no other U.S. person who can take your job, who is willing and able and qualified to take that job. Therefore, that is what we mean when the NIW has a higher bar, because it is a privilege that is given not only to anyone, but people who can prove to the government that they are coming to the United States to do something that benefits the national interest. All right. So the way that NIW cases are adjudicated is really focused on what is called the matter of Dennis-R three-prong test. And it's based on a 2016 case that came down at the AAO. And the three-prong test goes like this. First, the applicant must prove that their proposed endeavor in the United States has substantial merit and national importance. And that is measured by the prospective impact of their proposed work in the United States. Does your work tend to, advance the field as a whole? The second criteria under matter of Dennis-R is whether the applicant is well positioned to advance this endeavor. And this goes into the applicant's education, professional experience, record of success, previous related projects that they have completed that was successful, that, renders them well positioned to do what they're proposing to do. And the third requirement is that on balance, there must be a showing that it will benefit the United States as a whole to exempt the labor certification requirement for this particular individual. And there are various ways, various strategies you can argue that third prong as well, which we will go through in the following slides. In addition to meeting the matter of Dennis-R three-prong test that I just outlined, the applicant must also independently also meet the EB2 threshold, which applies to all cases, both the U.S. job offer-based cases and the NIW cases. All of these cases must also meet the EB2 threshold, which is basically that you are an advanced degree professional, and an advanced degree is defined as a master's degree, master's level degree, really anything higher than a bachelor. So Juris Doctor, a JD degree for lawyers, for example, also counts as an advanced degree. Master's degrees like MBAs also qualifies, and things like a medical doctor degree, even, for example, can also qualify as an advanced degree because it is above a bachelor's. You typically need to already have a bachelor's in order to gain admission to a medical doctor program. So that is how they defined advanced degree. Now, another way to meet the EB2 threshold is if you have a bachelor's degree in your field and 5 or more years of progressive work experience that you can prove. And what does progressive work experience mean? It means that the work that you have been doing, your job duties have been changing over time in increasing seniority and increasing complexity. And if you can prove that with detailed letters from your employers on a company letterhead, you may be able to meet the EB2 threshold with just a bachelor's if you have that 5 years of progressive work experience after you have obtained your bachelor's in your field. The other way you can meet the EB2 threshold, if you can show exceptional ability in the sciences, arts, or business. And the way to show exceptional ability, and we will go through that in more detail in the following slides, is to show at least 3 out of the 7 criterias, but it is a much lower standard than extraordinary ability. So this may actually be attainable for many, many people. So one advantage to mention here is that you don't need an employer to apply for a national interest waiver. And that's a key advantage that makes the national interest waiver a very attractive a green card option, because the foreign national is allowed to self-petition for a green card. So if you qualify for the NIW, you can self-petition as an individual. You don't need a U.S. job offer. Sometimes it can be helpful to have, letters of intent from, potential research partners or, potential business partners if you're, someone who's proposing a business plan. But there is no formal requirement for a job offer, and the person can self-petition as an individual. So as I mentioned before, the waiver relates to the EB2 requirement to prove that the employer cannot find a qualified U.S. worker. which is the perm labor certification requirement. And therefore, the challenge for the NIW is proving why your case merits this exemption from the ordinary requirements of a job offer and labor certification in the national interest. And one last thing to note before we move on is that there is really no limit for which field is relevant for the NIW. Really, applicants in any field can apply, and we have seen approvals from many different fields, including even lawyers, for example, people in science, definitely. But it is actually a common misconception that NIW is only limited to STEM cases. We actually also have seen many cases of approvals with entrepreneurs, even people who are, exceptionally talented in investment, for example. So really, there is no limitation to the field. The individual specific proposed endeavor is what's important, and it is not the applicant's field that is important. So we will go through more of that in when I'm talking about the national importance requirement. But one misconception is that if you're doing work in a attractive field like AI or STEM, if you're simply doing work in that field, do I qualify for an NIW? And actually the answer is no. No matter how attractive a field is for the government, really what's important is the individual's specific proposed endeavor. And so just the fact that you're working in an attractive field will not automatically qualify you for a national interest waiver. All right, so let's go through in a little bit more detail about the threshold requirements for the EB2, which is required for either the perm option or the NIW option. It doesn't matter. You still need to meet the EB2 threshold requirement. So as I mentioned before, you need to either show that you have an advanced degree in your field, which is defined as a master's or higher, and includes degrees like a JD or an MD, where you need a bachelor's degree in order to gain admission to that program. Degrees like an MBA can work, PhD degrees, Masters of Science, Master of Arts, those types of degrees will work. Or a bachelor's degree, if you have one, in your field, plus 5 years of post-baccalaureate progressive work experience in the profession. So your bachelor's degree and the work that followed the bachelor's degree must be related and must be in your field, and they must be related to your proposed endeavor. But given that, you can use this combination of work experience and bachelor's degree to be considered an equivalent of an advanced degree holder. Now, it is important to adequately prove that you have this 5 years of full-time progressive work experience. And what is important is to prove that with employment confirmation letters from your previous employers that will describe in detail how your duties have changed over time. And this can be, things like increasing responsibilities, seniorities, supervising people, and also can be, reflected by changing titles. So if you, start off as a junior engineer and then you become promoted to be senior engineer, and then a principal engineer at the end, that certainly will be helpful to prove that your work experience has been progressive. If your salary has raised, seen significant raises over time, that can also be helpful, and those kinds of content can be proven with those letters. Or so let's say you don't have a bachelor's degree, and let's say you don't have a master's degree, can you still qualify under the EB2 threshold criteria? And actually, if you can show that you have exceptional ability, you may not even need to have those types of degrees. So let's look a little bit at exceptional ability. How do you show you have exceptional ability in the sciences, arts, or business in your field? So you must show that you meet at least at least 3 out of the 7 enumerated criteria that is listed here. And this includes things like an official academic record showing that you have any degree. It doesn't matter if it's a bachelor's. You can meet that with an associate's degree or things like that, as long as it's relevant to your field. If you have full-time experience amounting 10 years in your occupation, that can also be helpful towards this. A license in your profession or field, evidence that you have commanded a high salary, for example. membership in professional associations. And really, the important thing here is to show that you have received recognition for your achievements and significant contributions to the field by peers, government entities, professional or business associations. And this can really be helped by getting letters from leading experts in your field, describing your original contributions, and also can be supported by objective evidence such as media articles featuring your work. If you have gained awards, recognizing your contributions to a particular field, if you have, been honored in industry shortlist or things like that, or if you've authored any intellectual property, publishing patents or journal articles or things like that. All of these things can be relevant to supporting that you have earned recognition for your achievements. So cumulatively, the evidence should tend to show that you have a degree of expertise that is significantly above what is ordinarily encountered in the sciences, arts, or business. And if you can convince the government that that's true, you will be able to meet the EB2 threshold requirement by showing that you have exceptional ability in your field. All right, so now let's move on and discuss the matter of Danazar factors, because meeting the EB2 threshold is not the end of the story. You still need to prove each of the three prong criteria under matter of Danazar to show that you actually qualify for the NIW, which is an exemption from the ordinary labor certification requirements that you need to go through getting a job offer from a U.S. company that needs your services. So what are the NIW requirements? The first prong of the Danazar test is that the applicant's proposed endeavor must have substantial merit and national importance. And really, I would say the most important step and the first step of the NIW process is to clearly define what is your endeavor. And to define the endeavor, the applicant must present a specific project or goal that goes beyond simply your plans to work in an occupation. And that is having increasing importance in the eyes of the government. And this is a trend that we have been seeing. The government will not accept just, a one sentence statement that you intend to continue working in your field as evidence of a proposed endeavor. The proposed endeavor must be much more specific than that. So the importance of the proposed endeavor, what does the government look at when they assess the importance of a proposed endeavor, which is your plan in the United States? The geographic scope is no longer the focus per matter of Danazar. Before matter of Danazar, they used to ask, what is the geographic scope of your work? So if does your work, impact or touch, all 50 states of the United States? Fortunately, now the government doesn't look at things that way. More importantly, what they look at is what is the prospective impact of your work to your field, or, to the public as a whole or to society. What are the benefits that we can expect from your work? And does that extend beyond your immediate employer or your immediate clients? So the broad impact to your field is what the government is looking for when they are assessing the importance of a proposed endeavor. So endeavors that tend to have national or even global implications within a particular field, such as improving manufacturing processes, or medical advances, um, developing new therapies, developing new drugs that can really, help, um, improve the efficacy of medical treatments, things like that, that have, broader implications on improving best practices are favorable for meeting the national importance standard. Or substantial positive economic effects can also be a factor. So, for example, if you are contributing to develop a new technology, a new design in a cutting edge field like semiconductors or mobile smartphone technology that may be widely commercialized and bring in, a large scale economic benefit to the United States by helping, the industry, become more competitive in the global market. Those types of endeavors is also favorable to meet the national importance standard in the eyes of the government. So what I've mentioned here repeatedly is that it is important to give the government a showing that the benefit goes beyond one's immediate employer or clients. So to compare that with an example, Where it would be more difficult to meet the national importance standard is if are running a pizza shop in your local area, and if, your work is only benefiting the immediate consumers who, like and purchase your pizza, uh, instead of, having a broader impact to, I don't know, the pizza industry more broadly, that would, have more challenges in trying to meet the national importance standard because the benefit of that kind of business is more localized. Substantial merit. So there is a little bit of a difference between how the government looks at substantial merit and national importance. And substantial merit is, a little bit more of an easier standard to meet, because even if you operate a pizza shop or a dry cleaning shop in your local region, you're doing something positive for the local economy. So even if the impact of your work is localized, you may still be able to meet substantial merit. But really the challenge is to meet national importance, right? And the important thing is that each applicant must meet both substantial merit and national importance in order to pass the first prong of the Danaher test. And national importance often focuses on the larger scale and broader impact of the endeavor, and is looking for more than a localized impact. So that can be the challenge. Now, let's talk a little bit about job shortage issues, which is a common misconception that we see sort of floating around the internet. Will you be approved for an NIW if you will be working in a profession where there is a job shortage? For example, we see this argument being floated around for pilots a lot. It is a well-known fact that the U.S. has a shortage of pilots. And if I am a pilot, and if I propose that I will be working in the United States as a pilot, is that enough to meet the national importance standard? And unfortunately, the answer is very clearly no. And the reason why is because simply working in a field is not going to meet the level of impact that the government is looking for when they discuss national importance. And what you will get if you submit an application like that in response is that the government will simply say, well, yes, there is a shortage of pilots in the United States, but that's why we have the ordinary labor certification requirement. And if you get a job offer from a US, airline, they will be required to go through this labor certification requirement and see if there is another US person who is willing to take your job and able to take your job. And if they don't, have this US person who applies, then they're able to, sponsor a foreign worker to take that job. And that is the ordinary requirements for, dealing with labor shortages that Congress has mandated. So just the fact that there is a shortage in a field will not automatically qualify an applicant for a green card under the national interest waiver category. Another thing to note before we move on is when we look at AAO appeals cases, there is some more detail on what the government is looking for when they look at national importance. And one example is teachers. So, so teachers may have a little bit of a disadvantage when they are applying for an NIW based on a teaching endeavor, because Matter of Danaher clearly states that endeavors like teaching only tends to only benefit their immediate circle of students. And so if your endeavor is only benefiting the people, the direct people who are, taking your classes, the government is still going to look at that as more of a localized benefit rather than the broad impact that they are looking for to meet the national importance standard. So really, the important thing to note here is what is your prospective impact to the field more broadly that goes beyond benefiting simply your immediate clients, your immediate students, the immediate employer, and really benefiting the field as a whole. All right, so then let's move on now to prong two. Well positioned, the applicant is well positioned to advance the endeavor. Here, the focus is not on the prospective impact of the work that you are going to do, but more focused on the individual. So what is your education background like? What is your professional experience like? Have you had a history of influence in your field? Have you had a history of successful projects that you have done that is directly related to the work that you're proposing to do? So they were looking for a track record of success in the field. So if you don't have any experience in what you are proposing to do in your proposed endeavor, they will consider that you are not well positioned to do that. So you do need to show sufficient related knowledge, skills, experiences that is likely to convince the government that you are the right person to do that job. Patents and intellectual property is always a good idea if you have a history of those kinds of technical innovations. Um, if you have authored, any journal articles or things like that and have had, a high number of citations, obviously those are classic forms of evidence tending to show well positioned. Another thing to note is it does matter how far along is your endeavor, especially if you're, doing something more on the lines of, doing a startup, launching a startup, for example. If you have already launched the startup, or if you have developed the startup in a way that you went through prestigious accelerator programs, for example, if you can show admission to Techstars or Y Combinator or things like that, evidence of such interest from relevant U.S. entities and industry leaders can be very helpful towards showing that you're well positioned to drive forward this endeavor because you have been successful in garnering this interest already. So that can be very helpful. If you have contracts with U.S. entities that are willing to work with you, work with your business, or willing to invest in your business, or things like that. All of those things can be helpful for well positioned. And if you are already in the United States developing your business, if you're on an E2 visa, for example, and if you already have an array of contracts with, high profile US entities, that can always be helpful in showing this traction. If you have had a history of growth, generating growth for your business in the United States, and if you can show that through tax returns, history of employing US workers through forms W-2s, for example, those can also be helpful in showing that track record of success if you're, trying to apply with an entrepreneurial endeavor. So now let's go through the third and last point, which is the applicant needs to show that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification in your particular case, such that you would merit this NIW, this preferential treatment in, getting a green card. So extraordinary ability considerations, so things like, awards, if you've been, invited to judge other people in your field, like things like that, usually what we rely on for EB1A. Petitions can also be relevant here, right? You can use those things to show that you are someone who is exceptional, extraordinary, someone who can't really be replaced by another US worker with minimum credentials. That can definitely be helpful on meeting the third prong, because if they lose you, then they lose some unique knowledge and skill set that you bring that can't really be found by the vast majority of other US professionals, even if they meet the minimum, minimum qualifications for that particular job. You can also look back at evidences that we use for prong 1 and 2. So if your particular proposed endeavor has the potential to broadly impact the field and broadly benefit an industry that is important to U.S. interests, so such systemic benefits can definitely outweigh the localized benefit of saving one job spot for one U.S. worker. So you can use arguments like that. Prong 2, well positioned, if you can show that you have, exceptional and rarely found expertise in a particular area that cannot be found easily by the vast majority of other professionals active in your field, you can definitely use that to your advantage. Another argument that entrepreneurs can make to their advantage is that Matter of Danosaur actually explicitly notes that for entrepreneurs, the traditional way of labor certification actually will not be practically an option that is available to them, because if you have ownership in your company, you are not able to sponsor yourself for the traditional labor certification requirements. So entrepreneurs can use that to their advantage and show that, hey, I have ownership in my company, so I cannot avail myself to the traditional method of a green card through labor certification. However, my business, by running my business, I'm actually creating jobs for, other U.S. individuals. So actually, Congress's policy of protecting the U.S. labor market is better served by approving the green card for me so that I can continue creating these jobs for U.S. workers. So that definitely can be, one leg up that entrepreneurs have on the third prong. But note that you must already have met the first and second prongs in order to get to the third prong. And just meeting the third prong without anything else will not result in approval of the NIW. And as I mentioned just now, Danisar specifically notes that entrepreneurial work can lead to an NIW and that the NIW can be a good option for entrepreneurs. And the case law actually does support explicitly that the planned business venture does not need to ultimately succeed as long as you can show that it is plausible that it will be successful. All right. So let's discuss national importance in a little bit more detail because in recent trends, that tends to be where there is a lot of challenge and pushback from the government. And I would say that is one of the more difficult prongs to meet among the three prongs that I just discussed now. So in order to meet the national importance standard, the applicant needs to prove the importance of the individual's specific proposed endeavor and really not the importance of the field or the occupation the individual will be working in. So, a common, misconception that I encounter in my practice is, oh, hey, I am an engineer and I am working in, environmental sustainability, which is a great, you know, an area of great importance for the United States. Can I apply and be approved for an NIW? And my answer to that always is it depends. And it depends on your specific proposed endeavor because not every engineer who works in an attractive field will automatically be approved for an NIW. And so it is very, very important for applicants to work with, lawyers who understand how targeted and specific proposed endeavor statement, should be presented, because it is very important to present a cohesive and plausible plan on how you are going to impact the field in a broader way. How is your insight going to be shared with the field, and what kind of, industry limitation are you helping to solve? Things like that. If, certain processes or procedures or scientific knowledges in the industry is lacking, how are you filling that gap? So really, the proposed endeavor statement is one of the most important elements of a successful NIW petition, because you need to convince the government that you'll be doing more than just working in an important field. And another thing to emphasize here is expert letters can indeed be very important on on making a petition strong, because letters from leading experts in the field can really dive into the applicant's specific plan and give the necessary context on why this is important and what will be the impact of this work to, the field as a whole. And so the expert letters, if they are detailed and if they are concrete, if they are persuasive, can really help on fleshing out the prospective impact of the proposed endeavor, because the government will look for evidence that the specific plan of the applicant has, this impact, rather than the importance of a field or occupation as a whole. And so, as I mentioned many times before, if your work tends to only benefit one specific employer, and if you're providing services, that is limited to simply, using existing approaches to benefit just one single company, that will usually not be enough to meet the national importance standard. There must be a showing of a broader impact beyond that. And they're looking for broader impacts to either a field or a region or the public at large. So let's look at some examples. So, and these are examples directly taken from the USCIS policy manual. So a person, for example, developing a drug for a pharmaceutical company may establish national importance, they explain, by demonstrating the prospective public health of the drug instead of solely projecting the profits that will accrue to the employer. So even this really shows that even with the same set of facts, the way that the proposed endeavor is presented can really make a difference. So if a proposed endeavor is presented in a way that emphasizes the public health benefits, that may become the basis of finding national importance. But if you prepare a proposed endeavor and only link that through, profits towards that particular employer, this under the same facts, the government may deny this, petition for lack of national importance. So this really shows the importance of the right framing when you're presenting your case. And other examples of where you can find national importance can include things like widespread interest in adopting or licensing a technology that you develop or you help develop, if you're developing a novel and important manufacturing process, or how, if you're developing a new technology, the technology stands to impact the development of similar technology by other companies. And so, if you're doing something that is at the cutting edge of a field, and if you can convince the government that whatever you're doing will result in follow-on um, endeavors by other companies to really catch up to that, then that can also count as a broad impact to the field that goes beyond benefiting your immediate employer, that goes beyond benefiting your immediate clients. Finally, substantial economic benefit can also be a basis of finding this broader impact. And if you are an entrepreneur and if you can show that you will be creating US jobs at a level that is significant with respect to a population or economy of a region, and this comparison really suggests that the number of jobs that the government is expecting is actually going to be pretty large. If you can show that, though, by evidences such as, tax returns and W-2 showing that you've already been creating that number of jobs, and if you can, do an extrapolation of that and say how you're planning to grow your business to, even increase the job creation further, maybe you can meet that threshold. But definitely note that the government is looking at a comparatively significant level with respect to a region's population. So this may actually be a higher bar to meet than you may think initially. All right, so then let's shift gears a little bit and talk a little bit about the practicalities of preparing and submitting a national interest waiver petition submission. So what is included in an NIW submission? So the first thing you need to make sure that you include in an NIW submission is proof that you meet the threshold requirement for the EB2. And I've explained before in previous slides that there are two ways you can meet the EB2 threshold, which is either by showing that you're an advanced degree professional or by showing that you have exceptional ability in, your field. If you are meeting this EB2 threshold through an advanced degree, you should plan to show the copy of your degree, which can be the diploma and the transcript showing that you've completed this degree. If you are meeting this threshold through a foreign degree, so if it's a non-US institution that gave the degree, it is very, very important to get the US education equivalency report because sometimes there is a mismatch between what level of, education it is. Sometimes a bachelor's degree in one country will not equate to a bachelor's degree in a US institution. So it is very, very important to get this in advance to make sure that the levels of the degrees are matching up. So definitely do that. And if you are meeting the advanced degree threshold by showing a bachelor's degree in your field and 5 years of progressive work experience in your field, it is very important to include detailed employment confirmation letters from your previous employers proving that you have had this 5 years of full-time work experience, and also to prove that the job duties that you completed in that position is progressively changing over time. So this can be shown by, increasing responsibilities, increasing supervision of junior employees, and also things like changing job titles, changing salaries, things like that. But really, mostly what's important is the job duties and the nature of job duties and how complex were the duties that you were expected to perform. Um, So if you are actually using exceptional ability to qualify for the EB2 threshold, you do need to show the 3 out of the 7 criteria of evidence to show exceptional ability. As I described in the previous slides, the totality of the evidence must tend to show that you are someone who is at a level that is significantly above what is ordinarily encountered in the field. So there is a bit of a qualitative assessment that goes in with exceptional ability as well. So now, the other part of an NIW submission is to present the evidence responding to each of the 3 prongs matter of the NSR test to show that your case qualifies for the national interest waiver. So, for example, for substantial merit and national importance, you can present a very detailed and concrete plan, a proposed endeavor statement that goes beyond simply planning to work in the field, but provides to the government why your work will impact the field in a broader way, how it will benefit the public, how your particular work will, result in broader benefits to the field, the region, the public, in a more, broader sense. And you can bring in many different evidences to back up your plan. If you're an entrepreneur, for example, a comprehensive business plan is definitely an important element that will really, contextualize and materialize your plans in the eyes of the reviewer. Government reports and mandates can be helpful, but I do put that with a caveat because really the evidence of importance must be specific to your work. It must be specific to your plan. So government reports generally saying that, oh, the, AI is important, or, oh, semiconductors are important. Without more, that's going to only have a limited benefit to proving the importance of your particular work, because you need to show what the impact of your work is to that field instead of just showing that the field itself is important. So that's why expert letters can really be helpful, because expert letters can be tailored to your plans and explain what the importance of that particular plan will be to, ensure the competitiveness of the field, for example. And so those letters can be used to demonstrate the substantial merit and national importance of the endeavor. And it is actually very positive if you can get a letter of support from a government official. So if you, I don't know, if you're a scientist and if you can get someone who is working at NASA to provide an expert letter describing your particular research project and why it has the potential to impact your field, that can definitely go a long way towards proving national importance. So definitely a strategic use of expert letters can help your case. Other types of evidences that we typically include are things like applicants' resume, degrees, and proof of professional accomplishments. So if you have provided, if you have proven influence in previous projects that are closely related to your proposed endeavor, we would definitely want to provide materials related to that and get expert letters describing your previous contribution to the field, why they were influential, what you did to advance the field more broadly, and back that up with objective corroborating evidence of your work product. For example, if you have authored patents, or, if you've presented something at a conference, for example, we would also, provide copies of those types of intellectual property contributions. So we will help you build a portfolio of your past record of success that can support how well positioned you are to advance your proposed endeavor. Entrepreneurs may also include evidences such as proof of contracts, letters of intent, and proof of startup capital to show that there is enough traction to that business project. That can be helpful for well-positioned as well. And other evidence that tends to show that you are doing something that is, irreplaceable, that is unique, that can, help advance the field in a broader way. Things like awards, the extraordinary ability, evidence, things like, you being invited to speak at places, or you being invited to judge others in your field, or things like that can always be included as, supporting evidence of the outstanding merit of your work, which supports that your particular skill set is not easily replaceable with another U.S. worker with minimum credentials. All right. So then let's talk a little bit about some recent trends and strategies for the NIW. There is no question that more and more people are filing for their green card petition through the NIW pathway. Um, in 2018, only about 8,000 cases were filed each year. By 2023, this has increased to 39,000 cases per year. And because of this huge jump in the number of people who are filing for the green cards under the NIW category, RFEs and denial rates have definitely increased as a whole. And most recently, even for the last quarter of 2024, the denial rates for the NIW has reached 39%, which is even a higher denial rate than EB1A. So you can really see how the government is really trying to stem the flow of NIWs, and it is getting a little bit harder and harder to be approved for the green card under this very versatile and flexible pathway. Even though it is versatile and flexible, the government has a huge amount of discretion on what they define as national importance, and therefore a lot of denials have been being issued, especially in recent years. So on January 15, the government actually also issued revisions of the policy guidance that clarify several of the NIW aspects that I actually discussed in the previous slides regarding national importance. They really narrowed down how they define national importance. And so it is definitely worth keeping an eye on how the policy will change given the new administration. We are keeping an eye on this and monitoring any movements. So definitely reach out to us if you'd like to learn more about the prospects of your particular case under these new guidelines. The last thing to go over in this slide would be entrepreneur-specific strategies. So we process a lot of NIWs for entrepreneurs. And one thing to note is that because entrepreneurs cases are a little bit special, it's a little different than the typical PhD researcher cases where you would have the typical, forms of evidence be a Google Scholar and, um, number of citations and publications and journals and things like that. But for entrepreneurs, the evidence of impact and the evidence of influence is different because it's not a research heavy field, right? Business is not a research heavy field. So what other types of evidence can be helpful? Things like significant media attention on the petitioner or the business or both, evidence of admission to prestigious accelerators such as Y Combinator, Techstars, or things like that. If the business project has received awards or grants from government affiliated entities, that can also be helpful towards showing national importance of that particular project. Letters by leading industry actors can serve as independent corroboration of the outstanding merit of a particular project. So those types of supporting evidences can be very important to support an entrepreneur case. So even if you don't have the traditional array of evidences like journal articles or citations or Google Scholar patents or things like that, there actually is a great variety of alternative forms of evidence that entrepreneurs can use to support substantial merit and national importance. Well positioned can be supported by ownership and critical role in the U.S. entity. Evidence of investment interest from U.S. entities can always be helpful. And as I mentioned before, incubator participation can also serve as support for well-positioned. Media attention, I mentioned that before, and history of revenue growth. That can actually be very helpful if you can show through tax returns, for example, that your particular company has been generating high amounts of revenues and jobs in the United States. That can definitely be helpful towards showing that you're well positioned to drive forward this endeavor. All right, timing and considerations. What are some considerations when moving from a visa to NIW? A couple of strategic considerations need to be, raised here. And one of them is timing. So although premium processing is available for NIW applications, you do need to also think about the backlog in priority dates, which means, every year there is a limited number of green cards that are available. And in recent years, actually since 2022, the NIW category, well, the EB2 category has been backlogged, which means more people are applying for a green card under the EB2 category than there are visas available. So we've actually been seeing priority priority date backlog that extends over a year, maybe around 1.5 years in recent cases, which means that even after you have your NIW approval, which is the I-140, that's the underlying petition, even after you have the approval, you may be waiting in line until your priority dates are current, such that you can go to the next step, which is filing for an I-485 if you're adjusting status to a green card holder in the United States, or filing for an immigrant visa petition through your home country consulate. That's the second step of getting a green card. And at the I-140 stage, you don't have an independent basis to continue living in the United States. So you may need to continue extending your underlying visa status while you wait for the priority dates to become current. So that segues into the discussion about underlying visa status, because if you are on a non-immigrant visa that does not allow for dual intent, such as a TN visa, for example, once you file the I-140, you may encounter more challenges when you're trying to renew your TN visa. So it can be a good strategy to first renew your underlying TN visa, for example, for 3 more years. And then once you have the TN visa, then you can take actions such as, filing the I-140, and try to get the processes finished within the 3 years that you have. But with the priority date backlogs, that is no longer a guaranteed processing timeline. Definitely reach out to us if you want to discuss more specifically about the processing timeline as of present, because that can be a very important consideration for some people. So the application process, as I briefly alluded to before, the first step is to submit the form I-140. That is the underlying NIW petition proving that you meet the EB2 qualifications and the matter of DANISR standard. And if you get approved for that, now you need to wait until your priority dates become current. So if the priority date says current in the visa bulletin, then it means that you were able to concurrently file the green card petition when you file the I-140. Right now, the priority dates are backlogged for the EB2 category. For the EB1 category, it's current in my knowledge, but for the EB2 category is backlogged quite a while. So in that case, you must wait until your priority dates become current before you can move forward to the next stage by filing an I-485 or filing for an immigrant visa through your home country consulate. And consular processing abroad is basically you're going to submit what is called a DS-260 and schedule an immigrant visa interview at your home country consulate. That process also takes about a year, but you can only really do that once the priority dates become current. So the actual timeline for you to get the green card in hand may actually take multiple years, although the actual NIW petition is can be adjudicated pretty quickly, especially if you use premium processing. You can get an answer within 45 business days, which is very quick. The other steps of actually getting a green card is quite elongated. But that is true for, even if you're getting, a US job offer and sponsorship, that requirement still applies. So having the NIW may, end up what do you call it, expediting a little bit within that timeline, because you don't need to go through the labor certification process. But when you apply for a green card, that still is going to take a long time. So you do need to be realistic about how long it's going to take. Is the EB2 category current? So right now, the EB2 category is not current. And we've been seeing anywhere between 1 year to 1.5 years of clients waiting for their priority dates to become current. So definitely that is one important thing to note when you're preparing for this process. Pros and cons of adjusting status in the United States versus consular processing. So if you're able to file the I-485, which is the adjustment of status application, changing from a non-immigrant visa status to a green card holder, you can do that if you maintain your non-immigrant visa status up to the point where your priority dates are current, and you can file the I-485. If you do that, you get a basis to continue living in the United States, even if you don't renew your underlying non-immigrant visa status. So once you file the I-485, you can continue living in the United States. You can even continue working in the United States once you get the employment authorization document that is tied to your I-485. So there are some benefits that you can take advantage of once the I-485 is filed. The benefits of consular processing is that And this also ties into the disadvantage of doing an I-45, which is that once you file the I-45, you can't travel outside the United States while your I-45 is pending. And your I-45 actually can be pending for a while. I would say generally about a year. I would expect that you'll be waiting for the I-45 to be adjudicated. So if you're someone who needs to travel frequently outside the United States and back in, then using consular processing may be a better option because you don't have that restriction on whether you can travel outside the United States without abandoning your application for a green card. So definitely pros and cons to either approach. The disadvantage of consular processing is that you don't get an independent basis to continue living and working in the United States while your green card application is processing. So you may be actually be stuck outside the United States for a while. And it really depends on your preference and your priorities. So definitely speak to a lawyer if you're trying to decide between adjusting status in the United States and consular processing. It also matters what you declare in advance when you're filing the I-140. So there is definitely an advantage of hiring a lawyer early on in the process so that you can answer the I-140 questions at the I-140 stage to give you maximum flexibility on whether to choose adjusting status or consular processing. Not all lawyers are familiar with that, so definitely it's a very important strategic point. Okay, so the final topic we're going to go over before getting to the questions is a case study of a successful NIW case for an entrepreneur. So let's discuss this case study. The applicant was an entrepreneur who's formed a small consulting firm focused on improving services to U.S. veterans. And in support of substantial merit and national importance, the applicant provided a bunch of evidence outlining the difficulties faced by returning veterans from Iraq and Afghanistan in the United States, and why was it important to provide competent services to these veterans, focusing on the limitations of existing approaches and programs on helping these veterans reintegrate to productive society, and really providing a specific plan on how this person planned to improve services by providing his own programming that significantly improved upon existing approaches. So definitely, it was important to provide a specific plan on how this person was going to fill these gaps left by existing programs. And letters from experts and leaders in U.S. military, government, and charitable institutions was able to, these letters were able to support why this applicant's particular plan had national importance. Applicant was well positioned to advance the proposed endeavor. In support of well positioned, the applicant provided letters from government officials in the person's home country, philanthropy leaders, and industry experts, attesting to the prior projects that this person had done that was directly related to the proposed endeavor. Which resulted in millions of dollars being executed in charitable funding and hundreds of veterans, being able to find jobs. Those kinds of concrete and broad impact that this person has realized in the past really served, to be powerful evidences of how this person was well positioned to advance the proposed endeavor, and also was corroborating evidence for the expected impact of this person's proposed work in the United States as well. So these letters may have helped both prongs. On balance, beneficial to the United States to waive the requirement of a job offer and labor certification. And in this instance, the person was able to rely on certain arguments, such as an entrepreneur who is self-employed, it will be impractical for this person to obtain a labor certification through a job offer from an independent company. And additionally, the demonstrated value of the services this person planned to provide and the track record of success in the field meant that even if other U.S. workers were available with minimum credentials, it would still benefit the United States to have this person really realize those systemic benefits that would impact a large number of people in the public interest. All right, so thank you for your patience. Let's go through the questions that came in. I believe we have several of them. Can you please cover the format of paperwork submission when responding to an RFE? That really depends on the content of the RFE. Usually, we would So, in response to each of the points that the RFE raised, you would organize the supporting evidence responsive to each of those prongs. So, if the RFE is, challenging national importance, you would gather additional evidence supporting national importance and, organize it that way. Really, this depends on what the issues were that the request for evidence has identified. So that would be a fact-specific answer. Is any evidence that was obtained after receiving an RFE considered in response to an RFE? Um, the answer to that is no. So the easy answer is no, because any facts that support eligibility must have been in place prior to the date of filing, as of the date of filing the original petition. So you can't go ahead and get new awards. You can't go ahead and get new publications in and add those new evidences in the RFE because those types of new facts were not in existence at the time the original NIW was filed. So you do need to be careful to only use additional evidences of facts that existed before the original I-140 was filed. All right. I am currently on an L1 visa. I have a bachelor's degree with 11 years of progressive employment. My wife and I have a bakery that we have registered here in the US. Can I use this bakery as my proposed endeavor? Now, definitely set up a consultation to discuss this in more detail, but just by looking at that fact pattern, a bakery can be risky because the benefits of that endeavor tends to be localized. It will be beneficial to the people who come to the bakery and, you know, consume your baked goods, but what is the broader impact to the industry? What is the broader impact to society? That may be not be so straightforward to argue. And the other problem is that your experience is in IT. There may not be able to there may not be a connection between your IT experience and advanced degree and your proposed endeavor as a bakery. So if there is that disconnect, that may not work for the NIW petition. What if you have plans to expand the business to other states and if your business employs people and adds to the economy? That is definitely relevant when we're talking about the prospective impact of your case. Definitely reach out to us so that we can discuss more specifics about this business. Is the endeavor limited to your qualifications or work experience? So if you are qualifying with an advanced degree, the endeavor must be related to your advanced degree. If you're qualifying with exceptional ability, the endeavor must relate to the area of exceptional ability. If you are qualifying with a bachelor's and work experience, your proposed endeavor must be related to both your bachelor's and also your work experience. So everything must be aligned. And the USCIS has actually suggested that they're going to look at this more strictly going forward with the January 15 updates to the policy manual. So definitely a very important screening process that you should go through. Can you pivot in an RFE to a business plan if one wasn't submitted in an initial application? So if there was a material change in your plans from your initial application, that can be risky because the approval will only be based on the version of the facts that are initially submitted. So maybe in those types of cases, submitting a new petition may be a better idea, but definitely for specific questions like that, the consultation is a better way to deal with those questions. My priority date is current. Is it beneficial for me to file under EB2 NIW now, or wait for the new policy guideline coming from the new administration? Definitely, this question I would like to answer on a consultation as opposed to going through now because I don't have all the relevant facts in front of me. So reach out to us and schedule one. How much citations and research papers needed? There is no minimum required in the law or the regulations of how many citations you need. The important thing is how can you show impact of your prospective endeavor and your prospective research? And many different types of evidence can be used to support that. But if you have no evidence and if you just have citations, that can also be a risk. So definitely get in touch with us. We will be able to look at your CV and provide you some preliminary assessments based on your particular proposed endeavor and your particular background. Can you give an estimate of the cost of consultation and the fees? So, if you look us up online, Scott Legal Consultations, the fees for the consultation is listed there. With regards to the fees of us preparing your NIW petition for you, that is based, that information can be provided at the consultation. Well, we'll be sending you our engagement letter after the consultation, so you can get that information when you reach out to us separately. All right, so I believe I went through all of the questions. Thanks everyone for your active participation. I hope this information was helpful to you. If you'd like to discuss your particular case in further detail with me or any other experienced attorney, please feel free to reach out to us and we'll be happy to take a look. Have a great day.